Before you judge him, listen closely because what you're about to hear could destroy a life forever. The man sitting before this judge isn't just another defendant. He's accused of one of the most severe crimes in the legal system: first-degree criminal sexual conduct with a child under 13. The air in that courtroom, heavy, the prosecutor's eyes, fixed, the defense, silent, waiting for their turn to strike back. But remember, every case has two sides, and sometimes, what's said in the courtroom isn't the full story. Stay with this one, because the tension's only just beginning to rise.
The Chief Public Defender is present with us. And also present is Angelique Canfield from the prosecutor's office, and their victim advocate is also present. Good afternoon, sir. What's your name?
Cody McCoy.
All right, Cody Edward McCoy. Mr. McCoy, I'm Judge Middleton. You've been charged with a very serious offense. Let me get to it. Darn it. Sorry about that. Let me get at it. She can have a seat here. We'll be with her in a minute. As I indicated, this is file number 251883, Cody Edward McCoy.
When a judge starts listing charges that carry life imprisonment, you can feel the gravity settle. Each word, sexual penetration, under 13, felony punishable by life, echoes through the room like a verdict already delivered. For viewers who don't follow court cases often, understand this: first-degree CSC isn't just serious, it's among the harshest in Michigan law. And yet, despite the weight of it all, McCoy's expression barely changes. Is it composure or something colder? That's for you to decide.
Mr. McCoy, the allegation in this case is from January of 21 to July of 24, sometime during that period. That's a pretty broad period. You did engage in sexual penetration with a child less than 13 years of age. That is a felony punishable by up to life or any term of years. Second count is criminal sexual conduct in the second degree. It's alleged that you did engage in sexual contact with the same child who was less than 13 years of age, and that is a felony punishable by up to 15 years imprisonment. Count 3 is another count of criminal sexual conduct in the second degree. One count of criminal sexual conduct first degree, and 2 counts of criminal sexual conduct second degree. Those are very serious charges, punishable by up to life imprisonment. First thing I'm going to do is I'm going to indicate that you're going to plead not guilty to these charges.
Then comes the moment that flips the energy of every courtroom: not guilty. Those 2 words reset everything. Suddenly, it's no longer about accusation, but proof. This is where the game of evidence begins. And while the judge moves on to set hearings and dates, remember, these aren't just calendar entries. Each one represents a step closer to either freedom or life behind bars. Would you have the nerve to say not guilty in his position?
You have a right to hire a lawyer, but I'm going to make sure that you have one. I'm going to appoint an attorney for you. Set a pre-exam conference for September 30th at 8:30. And if we need a preliminary examination, it would be October 7th at 1 o'clock. Mr. Moore, what's your occupation?
Mr. Moore or Mr. McCoy?
Oh, excuse me. Mr. McCoy, I'm sorry. I was looking at another file. I wanted your. What's your occupation? Do you work someplace?
I'm a welder
Where's that?
at a little fab shop called Ash's Fab. It's just me and the boss.
And where is that?
White Pigeon. I'm not sure of the exact address.
How long have you worked there?
Since May.
Here's something subtle but powerful when McCoy answers the judge's questions about his job and address. His tone stays polite, calm, almost ordinary, but that's what's chilling. Because calmness under these circumstances, it's not normal, it's deliberate. Every defendant knows that the judge is reading more than their words. They're reading behavior, posture, attitude. The smallest hesitation can shift perception. It's not just a legal process, it's psychological warfare inside that courtroom.
I believe.
Now, this is alleged to have occurred in Sturgis. Do you still live on Airline Road in Sturgis?
Yes, sir.
All right. Are you on probation or parole?
No, sir.
Have you ever been convicted of anything like this in the past?
No, sir.
They didn't list any supplemental. This is shame on me. I don't have a criminal history in here. I didn't see anything in my system, but I didn't see anything elsewhere. Have you been convicted of anything in any other state?
Just the OWI,
And where was that?
Indiana.
Who do you live with?
Just myself.
All right, as I indicated, Mr. Keith Stickley is here. He'd like to speak with you privately in what's called a breakout room. And I wanted to get some of the particulars out of the way. And I'm going to put you in a private space where you can talk with him, and then we'll talk further.
This is where things heat up the bond discussion. Whether McCoy walks out that door or spends months behind bars could depend on what happens next. The prosecutor is about to step in, and what she's holding isn't emotion, it's statute. She's ready to argue that the law itself gives her the right to keep him locked up before trial. Watch how she lays down her case. It's not passion, it's precision.
Okay.
All right, Mr. McCoy, one of the things I need to do at this hearing is set a bond. The first charge is what's known as a capital offense. It's punishable by up to life imprisonment. The prosecutor's office is here, and I'm sure they'd like to speak to that issue. Ms. Canfield, what would you like me to know about the prosecutor's input regarding bond?
Thank you, Your Honor. As I'm looking at MCR 2.306, no, I'm sorry. 6105, nope, it's 6106. Parents B1B. It does indicate the court has the authority with the criminal sexual conduct, first degree armed robbery or kidnapping. If they find proof that the defendant's guilt may be evident or a presumption is great, the court can.
Listen carefully to Prosecutor Campfield's words. She isn't storytelling, she's building. Every phrase, every citation, designed to tighten the net around McCoy. When she mentions proof evident or presumption great, she's invoking a legal weapon that allows judges to deny bail altogether. It's rare and it's powerful. Her tone says it all. This isn't just a case she's handling, it's one she personally authorized. That means she believes, without hesitation, that the child's statements are enough to hold this man. The question is, will the court agree?
Deny pretrial release under that circumstance. This is one of those difficult cases, however, where it is a young child who disclosed to another child. I'm the one that authorized this particular case, so I'm very familiar with the facts. I did view the interviews of the child after the original disclosure to the sister. The children then went to the mother. The mother then called, as appropriate, the police, took the child for examination, and then subsequently for a forensic interview. There were disclosures not only to the sister, but to the forensic interviewer, that in my training and experience as a prosecutor for over 15 years and a criminal attorney for almost 29 now, that there's a preponderance, at least a very strong one, which is why I authorized it the way that I did. Now, when we look at his criminal history, it is accurate. There is only, to my understanding, no Michigan history and an Indiana history of only an operating while intoxicated, and that was in 2017. When you look at the factors under 6106F, he doesn't have a significant criminal record or one that indicates these types of crimes happening previously. He appears to have resided in the community for a period of time, and his ties to the community would be the fact that he is employed and has a home, and apparently his grandmother in the area. My understanding is that the child currently resides out of the state and only came into the state for parenting time, which is allegedly when these offenses occurred, was during the parenting time. So my understanding is that there is no contact between the minor child alleged victim and the defendant at this time, and hasn't been for quite some time since the disclosure.
Here comes the emotional crossroad, the risk factors. The child lives out of state, contact cut off, but the prosecutor's fear lingers. What if he leaves? What if he finds a way back? This moment exposes one of the justice system's hardest dilemmas. How do you protect the innocent without condemning the accused? Every condition she lists, no contact, GPS tether, no alcohol, isn't just precaution, it's protection wrapped in policy. But does it also hint at uncertainty in the evidence itself?
So I can give the court that information. It is a very serious offense, which obviously falls under for F, let's see, F1E. The seriousness of the offense can be considered as along with any threats or whatnot to the victim. Because there is no contact and the minor child resides out of the state, one would think that the risk factor would be less or lesser than if they were residing together at the time. But my concern in instances like this are if he's released, he does have the ability to travel. I'm presuming he has a vehicle to get to and from work. She doesn't live very far out of the state. So that is a concern. She is very young. And it's his own child that's the alleged victim. So that also causes concern of the defendant being on bond release and around any other children. So if there is a bond set at this point and it's not denied under 6106B, I would request that the court put in a no contact provision for the victim, her sister, and the mother of the minor child, that there be a no contact provision with any child under the age of 16 without supervision.
Now, this part might sound technical, but it's crucial. When prosecutors talk about tether with GPS, it's a modern leash freedom under surveillance. The judge could let him walk free, but every move, every drive to work, every wrong turn will ping law enforcement. It's a compromise between liberty and fear. And in cases involving children, that compromise often leans hard toward control. The system doesn't gamble with risk, it eliminates it.
And that the court consider a tether, although I know, depending upon where he is employed and his financial means, that may be a little bit straining on the defendant, but a tether with GPS that places him in the state and at his place of employment and residence, so that we know if he goes outside of that zone or attempts to leave the state, we'd have a little bit more alert for the safety of the victim if that were to occur. I think there should be no alcohol and illicit substances other than those that are prescribed by a physician while on bond. And that we'll see he and his counsel on September 30th.
All right. Mr. Stickley, you have any input regarding bond?
Enter the defense, calm, respectful, but firm. This is where tone becomes a weapon. While the prosecution spoke like a storm, the defense sounds like reason. He argues for equity, logic, due process. It's classic courtroom contrast, emotion versus procedure. His main pitch: no criminal history, no flight risk, no reason to cage a man who hasn't been proven guilty. For viewers, this is the eternal clash. Do you protect society first, or protect the presumption of innocence?
I do, Your Honor. I would have to stipulate that and agree with the people that this isn't, in fact, an offense that potentially the court rule regarding no bond would be applicable. And I guess I appreciate Mr. Counsel laying out I guess would be a good chunk of my argument that that being said, there are some mitigating factors, I think, to his benefit that would show that there is not necessarily a immediate risk to the community and or his ability not to show up. He doesn't have any sort of criminal record or track record of not appearing in court. I would ask that the court set a bond, the court set an equitable bond, perhaps even a PR bond with electronic monitoring. That might be very appropriate in integration with community corrections. I think that's the reason for community corrections. Any alleged victim, as has already been put on the record, I don't think resides in the state. I don't think that there's been any contact between the two. I'm hesitant to give a full timeline, but my understanding it's been the greater part of a year, maybe more. In terms of him being a flight risk or not participating in court, which is obviously the purpose of bond, is community safety and ensuring showing up to court. My understanding is I think that this gentleman knew that this was sort of kind of out there and did not remove himself from the situation or run. He allowed himself.
I got the impression this investigation had started once before and stalled out, and it got resurrected.
So
And here comes the reveal that reshapes everything. The investigation didn't start here. It stalled, then resurrected. That's massive. In legal storytelling, timing is everything. A case that pauses and restarts years later often brings one question to mind: why now? Was it new evidence or renewed pressure? The prosecutor mentions reviewing old interviews herself, a move that signals caution and confidence. Whatever the reason, the delay adds mystery and doubt.
He absolutely promises to show up to court. I don't think that he's run. I think that there's been that opportunity if that was going to be the case. He's asking the court to grant him perhaps even a PR bond with conditions, and no contact is kind of a no-brainer. We'd have no problem with that whatsoever, and enforcement however you'd like.
All right, thank you.
Your Honor, I think what happened with any delay in charging is the fact that this was a very young child initially when it occurred, and it was disclosed to the sister a little bit later. And then because the investigation began out of state, that agency was involved there in Indiana, as well as Child Protective Services in Indiana, that then realized that the actual event occurred in Michigan jurisdiction at the defendant's home during parenting time, which is why it was then shifted to an agency here to complete that investigation and submit for charging. It was at the office and was assigned to me after I became employed here in July. And I did take the time to review the evidence and the videos of interviews before I authorized what I felt were the appropriate offenses.
All right, thank you all for your input.
However, in a case like this, I respectfully disagree with Mr. Stickley. Although we have a victim out of the state, when we have any criminal sexual conduct that's alleged to have occurred, there does appear to be a risk to the community, and particularly the children that are minors.
Now listen to the judge. His tone isn't angry, it's weary. You can feel the weight of years spent hearing similar stories. Risk to the community, he says. That phrase carries history. Every judge has ghosts of past cases, the ones that ended badly, the ones that haunt decisions like this. When he talks about child victims he's seen before, it's not just law, it's memory speaking. And that memory may already be guiding his verdict.
All right, I'm gonna order some bond conditions and no drugs and no alcohol. No contact with the complainant, NM, her sister, whose name I don't know, or her mother, and you know who those parties are, or any child under 16 years of age without adult supervision. You're not to possess any weapons or firearms, and not to engage in any assaultive or threatening behavior. If you are released, you're to be under the supervision of the St. Joseph County Community Corrections with a GPS tether. When I was prosecutor, I handled literally hundreds of criminal sexual conduct cases. That sounds terrible even to say it. I tried 46. I had 2 people today in my court that were child victims when I was prosecutor. From the affidavit, this case seems to rest solely on the shoulders of a 6-year-old girl. I didn't see anything else. I didn't see any forensic evidence like DNA or anything like a recorded phone call or a fingerprint or that sort of thing. There may be a medical evaluation of the child that occurred, but I didn't see it as part of the affidavit. It's entirely her testimony as a very young child about things that happened to her when she was younger still. I'd fall off the cliff of the earth if I were to grant a PR bond and a criminal sexual conduct first-degree case. Bond in this matter is $100,000 cash or surety.
And there it is, the decision that defines everything. A $100,000 bond, cash or surety. For McCoy, that's a wall made of money. Either he climbs it, or he stays behind it. The judge admits there's no DNA, no physical evidence, only the child's word. But in crimes like this, that word can carry more weight than a fingerprint. This is the razor's edge of justice when emotion and law collide, and the balance could tilt either way. How do you think the judge handled it?
With the conditions as listed. The bond can be revisited if you do not post it at the time of the pre-exam conference or of the prelim. This is a very serious charge, very young child, multiple occasions. That's my ruling. So the bond is $100,000 cash or surety with conditions as stated. If you do post the bond, you need to immediately check in with the Community Corrections Department. And that information is on the bond form, and contact your attorney. If you don't post the bond, which is what I expect, your attorney will be coming out to see you at the jail in preparation for that pre-exam conference on September 30th. Mr. McCoy, you're free to go back with the court's jail staff.
All right, let's talk about that.
Thank you.
All right,
Judge
thank you.
Middleton.
So, here we are, an 18-minute hearing that could reshape 2 lives forever. The judge stands firm, the defense stays calm, and the truth, still tangled in testimony. What makes this case stand out isn't just its seriousness, it's its silence. The unanswered questions, the lack of evidence, the tension that never quite breaks. As viewers, we're left in the same space the court is between doubt and justice. If this case shocked you as much as it did us, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.